much all broke loose. It didn't break loose because of a Supreme Court decision. It broke loose because the left has decided, along with the media and the Democrats, but I repeat myself, to lie about the Supreme Court decision in order to revive the flagging hopes and dead body of Joe Biden. Let me begin at the beginning. Yesterday, the Supreme Court released a decision about presidential immunity. Now, this decision, of course, is rooted in Donald Trump filing a lawsuit to stop the various Jack Smith lawsuits against him. His claim was that as president of the United States, no matter what he did while he was president of the United States, he has full immunity from criminal prosecution. That, of course, is not true. That is a step too far. The idea that the president of the United States is never, for any activity, able to be criminally prosecuted is really silly. If the president of the United States decided that in his home, in the White House, he was just going to murder a maid, for example, could he be criminally prosecuted? The answer, of course, is yes. However, there is the idea that the president is, in fact, criminally immune from certain activities that a normal person would not be. So, for example, if I authorized somebody to go kill somebody abroad, I'd be criminally liable for that. If I'm president of the United States and as commander-in-chief, I authorize SEAL Team 6 to take out Osama bin Laden, I'm not going to be criminally liable for that. So there's plenty of stuff that the president of the United States...
What if you ordered SEAL Team 6 to kill your political opponent?
...has to be able to do in order to ensure the functioning of the executive authority of the United States. The president does have outsized powers under our Constitution. Those powers are not endless. Immunity is not eternal and endless. That is not the way that immunity works. And that's basically what the Supreme Court found. So in order to understand why the left is lying about this decision and why Joe Biden is lying about this decision and the political games that are now being played, you have to understand the decision itself from the Supreme Court. So I'm going to go through that decision in a little bit of detail because the sort of final effect of this as far as President Trump is that there are a couple of charges that Jack Smith has been pursuing that are basically DOA, and then there are several charges that are not DOA, and that will likely be upheld when this thing is reverted back to the D.C. Circuit Court of Appeals, because that's effectively what the Supreme Court did. They took a couple of charges. They said the president has immunity for this sort of activity, and then they said about many of the other charges, we're not going to rule whether the president has immunity on this sort of activity. We instead are going to send it back to the D.C. Circuit Court of Appeals to determine whether the president has immunity. Judge Chutkan is the judge in that particular case. Presumably, she's going to rule that President Trump does not have immunity on those particular charges. So, in essence, this is a very in-between decision. Now, you could have known that by the fact that the writer of the decision was Chief Justice Roberts. Chief Justice Roberts is, in fact, a fairly moderate justice. He is not Justice Samuel Alito. He is not Justice Thomas. He is not one of the more right-wing members of the federal judiciary. Remember, it was just...
To be clear, I don't know anything about like when Pisco says like the center of the court is, I think he said Roberts, or I don't know anything about like the political leanings or whatever, but just from the, and I've only read probably 4 Supreme Court decisions like cover to cover my life because I haven't had Vyvanse for very long, but from my reading, I feel like Barrett seems to come off as more reasonable. Roberts' opinion in this case is fucking unhinged. If Roberts is truly the center of the court, I don't know how you square, or maybe just in this particular decision, he's been a little bit more off the hook, but I feel like his decision is wild here. It would be crazy to think that this is like a moderate conservative decision on what federal powers should look like, in my opinion, but...
Hello.
Hello?
Hey.
Hi. What's up?
I was meaning to jump on at some point. I was actually just curious to get your opinion on the Supreme Court judges and like specifically Kavanaugh and Barrett and whether you think they're like as bad as they...
I have not read anywhere near enough opinions to be able to give like good, accurate evaluations of their rulings. So I wouldn't even begin to be able to, yeah. I would never trust anything I would say on that, yeah.
Gotcha. No gut feeling vibe check?
I mean, I like most of what I've seen from Barrett so far. Obviously, Sotomayor, she likes to write a lot. She seems based, but also I'm a liberal, so I might disagree with her in general. Actually, I am a little bit salty that the 3 of them changed their dissenting in parts to concurrences over the 14th Amendment thing, but otherwise, I don't know enough about any of these people to give you a good legal evaluation.
Gotcha. Okay. Yeah, no worries. I was just curious because I think, reading this Supreme Court decision, I'm kind of surprised that Barrett isn't more in line with what Roberts is, specifically because of the analysis you were talking about of people saying Roberts is a little bit more to the center? Because I think it's the case, right, that Barrett disagreed over the usage of the absolute immunity stuff for evidence for certain cases. Or
Yeah.
have you not finished reading through it yet?
Nope, I'm still reading through it, but
I'll hop back on later.
okay.
I
I love you. Be careful. Bye. Okay. Fuck, I'm not going to finish this today. All right. Let's go. Sorry. Back to here, back to here. The main takeaway of today's decision is that all of the president's official acts defined without regard to motive or intent are entitled to immunity that is at least presumptive and quite possibly absolute. Whenever the president wields the enormous power of his office, the majority says, the criminal law, at least presumptively, cannot touch him. This official acts immunity has no firm grounding in constitutional text, history, or precedent, citing in Dobbs v. Jackson Women's Health Organization. Indeed, I wonder who she's citing here. Who the writer was for that. Indeed, those standard ground, is it him? Is it Roberts? Or indeed, those standard grounds for constitutional decision-making all point to the opposite direction. No matter how you look at it, the majority's official acts immunity is utterly indefensible. The majority calls for a careful assessment of the scope of presidential power under the Constitution. For the majority, that careful assessment does not involve the Constitution's text. I would start there. The Constitution's text, it's the majority by Alito, gotcha. The Constitution's text contains no provisions for immunity from criminal prosecution for former presidents. Of course, the silence of the Constitution on this score is not dispositive, U.S. v. Nixon, insofar as the majority rails against the notion that a specific textual basis is required. It is attacking an argument that has not been made here. The omission in the text of the Constitution is worth noting, however, for at least 3 reasons. Sorry, okay. First, the framers clearly knew how to provide for immunity from prosecution. They did provide a narrow immunity for legislators in the speech or debate clause. We did read this clause, yes, and that is indeed provided. They did not extend the same or similar immunity to presidents. That's interesting because the president does speak in Congress at times, right? When the president does like the State of the Union and stuff, that's in that's in the Capitol, right? I just assume it is. I don't know, maybe it's not. Where is the State of the Union given? It is. Okay, it is in the Capitol, right? Okay. Maybe it was another fucking fancy building. Okay, just making sure. Destiny only read up to page 22 of the ruling. Michael Knowles read the ruling in all documents since the founding of America. True. Fuck. Yeah, I shouldn't have read your comment there. Can I just say that... Hold on. I can't tell if people know this. I need to not feel guilty doing this. I do feel bad doing it. I just stop. I need to just start quizzing people more. It's such a bad, it's a mean debate tactic. It's a mean debate tactic, but I need to just start doing it more. Because people do it to me. And I think that when people do it to me, you can quiz me because I know what the fuck I'm talking about. But I don't know if the audience is always understanding what's happened. We can't see? Yeah, I know. Hold on. Where is the link to the Michael Knowles thing? where he tries to ask me, he's like, did you read the ruling? First of all, by the way, this ruling had come out like fucking 2 hours earlier. It's 120 pages. I don't think he read even a single page of this, okay? Bullshit. But, Destiny, Piers Morgan.
Talking about this, remember before the debate,
Biden's debate.
American.
What about Matt?
Most responsibility for 3 hours a night. I had a lot of.
You know, at this point, obviously.
What did he say? Did he say read the ruling? What did he say? Show transcript. Read?
Destiny. They're yes,
To
the
be clear,
Democrats
that is
are upset. They're
absolutely not true.
inveighing.
That this is
Just
based
let me
on
finish
precedent.
1 second, Destiny. They're inveighing because they say we should be talking about the immunity case. Well, but part of the articulation of I just was reading the decision was that look, this is the first time that you've got a president who's being prosecuted in this way, and that's the problem because the vast majority of Americans, right, left, and center, have been saying in survey after survey that they view the prosecutions of Trump as primarily politically motivated. They view this as kind of corrupt. And that's one of the reasons why Biden's poll numbers have been so bad for so long. And so they throw this Hail Mary to do a debate in June before either party has settled on a nominee. And it completely blew up in their face. And so no wonder people want to talk about it. You've got a political order that is fraying. You've got a guy trying to put his opponent into an orange jumpsuit. And it turns out the guy who's trying to do that has applesauce for brains. No
And you
wonder
know what?
people
You know
are
what? The
concerned.
American people, a bit like the British,
Wait, was it not
to
here?
happen. The first ethic in you go. Where we are with this. What do you think?
Replace Joe. Yeah.
And that's right. See,
Has guidance that this has been articulated by Joe Biden and to be able to put
come to you, then come back to Tom.
Going to have to seat a judge.
Democrat side. That's going to be polarizing. Is on
The way, but if what you want.
More,
he
let's go.
sucks. Other
so someone else is running the country, whether that's GL
Control F 20 or 25 pages? Oh, wait, maybe it was over here. Hold on.
to bring in a bunch of, I don't know, drug dealers and hookers or something, that would probably be an unofficial crime, not related to his duties as president. And the reason that this matters, and why it's really a moderate decision, is because it goes back about 40 years.
Oh, he says it's a moderate. Okay.
Execution.
You
do a kind of
have you read the decision?
what that act? No, it's just partial immunity for official act.
He did it. Hold on. I'm sorry. I just thought it was funny that.
What is an official act of the president? If you actually listen to the oral arguments that were presented before the Supreme Court, what that act even is, and the ability to even probe for it, is stuff right now that is now presumed to be immune. For instance, just a real quick thing. When Donald Trump is asking Pence, "Hey, can you throw out the election because I don't like the results?" which is a real thing that happened, by the way. As much as Trump's like to say that's not true, that is counted as an official action because these are the roles of the president and vice president, deciding how to count the electoral votes. That is insanity to me. If Biden were to do anything even remotely similar, Republicans would lose their minds.
Have you read the decision? I know it just came out this morning, but have you gone through the decision yet?
So the really funny thing is that if he would have read, so now that I've read the entire decision, I actually gave not the best example because the example that I gave is the one that Robert said would get presumptive immunity. The absolute immunity example I should have given was the attorney general conversation, not the conversation between Trump and Pence. So I know he hasn't read the decision at this point now because he wasn't able to give that counterexample to me when we spoke. But my example is still good enough. It's, suffice to say the presumptive immunity would have been similar enough to be used here. But he hasn't read it at all, so he can't even give that counterargument. But it's funny that so he asks me this to try to get me to say, like, "Oh, I'm just a liberal. I can't read."
I read up to page 25, and part of it, I can read it out to you.
And then he laughed. "Oh, you only read up to 25? You only read up to page 25?" Like he's laughing, like he's read the whole 120 pages in the hour before we went live.
I read up to page 25, and part of it, I can read it out to you. He explicitly calls out that whenever the president and vice president discuss their official responsibilities, they engage in official conduct, meaning that presiding over the January 6th certification proceeding, at which members count, yes, so that did count as official conduct. So if you thought that he was trying to do a coup, try to steal the election by saying, "Hey, do you think you can throw those votes out?" Well, that's beyond prosecution.
You can dispute or object to any action.
Clearly, he has not read it, and now he's fucking. But I don't know if people recognize what's happening here. When things like this are happening, he's shit testing me to see if I even knew what I was talking about, or if he could get me to admit. He's like playing chicken with me, right? He's like, "Oh, have you actually read it?" It's like, yeah, here's like a part that I'm referencing when I say that. He's like,
you can dispute or object to any actions that Trump takes, but it is simply the case that when a president is carrying out his...
But yeah, this... If people are going to do this to me, I should just do it back to them. Tell me what was your takeaway from that? But anyway, I feel like it makes me an asshole when I do it. I don't know. Anyway, when they quiz you, you answer succinctly and honestly. When you ask them even a basic question, they use it as an excuse to yap, yap, yap and dodge to something else. You must keep interrupting them even if they bitch about it. I can't, on Pierre's, I get like, he'll cut you off if you're like interrupting too much. They don't like it when you do it too much. So I was trying in this conversation, but there are multiple times you can hear like my mic gets lowered and then Pierce keeps talking. I have to basically, yeah. But anyway, okay, sorry. It's taking us days to get through this. All right. Any shot you debate Knowles on Trump or Biden? I don't know. I'm taking a few days to do some shows, I think on the 11th. One of the shows I'm doing on the 11th is going to be Michael Knowles' show. So we actually have a full show that we're doing on the 11th that I fly up to do. So, oh boy. But that's over. It's like a week and a half away. Unless he cancels because of our Piers Morgan appearances. They did not extend the same or similar immunity to presidents. Second, some state constitutions at the time of the framing specifically provided express criminal immunities to sitting governors. Brief for scholars of constitutional law at Amici Curiae. I don't know how to pronounce this. I'm not going to try, sorry. Okay, that's actually a really strong historical argument, which originalists and textualists love to use. I think that's a good one to point. State constitutions, some state constitutions actually did provide for criminal immunity for sitting governors. This was not included in the U.S. Constitution. Whatever you do, Destiny, don't quote from the dissent. Nothing says I lost my argument as fast as reading from the dissent. Wait, what? Okay. The framers chose not to include similar language in the Constitution to immunize the president. If the framers had wanted to create some constitutional privilege to shield the president from criminal indictment, they could have done so. Third, insofar as the Constitution does speak to this question, it actually contemplates some form of criminal liability for former presidents. The majority correctly rejects Trump's arguments that a former president cannot be prosecuted unless he has been impeached by the House and convicted by the Senate for the same conduct. The majority ignores, however, that the impeachment judgment clause cuts against its own position. That clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. That clause clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted in an impeachment judgment, including conduct such as bribery, Article 2, Section 4, which implicates official acts almost by definition. Article 2, Section 4 provides the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for the conviction of treason, bribery, or other high crimes and misdemeanors. That's also a really compelling argument. Article 1, Section 2. Why do they use that weird S? What's this? The alt thing for that? Okay. Oh no, wait. Article 1, Section 3, Clause 7. Plus the nevertheless for criminal prosecution. Things like bribery are official acts for which one can be impeached. So any citations of this part of the Constitution seem to imply that criminalizing official conduct was textually available or was textually supported by the Constitution. Aware of its lack of textual support, the majority points out that this court has recognized presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. That is true as far as it goes. Nothing in our history, however, supports the majority's entirely novel immunity from criminal prosecution for official acts. The historical evidence that exists on presidential immunity from criminal prosecution cuts decisively against it. For instance, Alexander Hamilton wrote that former presidents would be liable to prosecution and punishment in the ordinary course of law. We read that yesterday in Federalist Number 69. For Hamilton, that was an important distinction between the King of Great Britain, who is sacred and inviolable, and the President of the United States, who would be amenable to personal punishment and disgrace. In contrast to the king, the president should be subject to personal responsibility for his actions, standing upon no better ground than a governor of New York, and upon worse ground than the governors of Maryland and Delaware, whose state constitutions gave them some immunity. At the Constitutional Convention, James Madison, who was aware that some state constitutions provided governors immunity, proposed that the convention consider what privileges ought to be allowed to the executive. There is no record of any such discussion. Delegate Charles Pinckney later explained that the convention which formed the Constitution well knew that no subject had been more abused than privilege, and so it determined to limit privilege to what was necessary and no more. No privilege was intended for the executive. Other commentators around the time of the founding observed that federal officials had no immunity from prosecution, drawing no exception for the president. Real quick, the footnote. To note, as the majority does, that the court has recognized civil immunities arguably inconsistent with this view is not to say that Pinckney was wrong about what the framers had intended. Indeed, Pinckney's contemporaries shared the same view during the ratification debates. And then the quote is, if the president does a single act by which the people are prejudiced, he is punishable himself. If he commits any crime, he is punishable by the laws of his country. Ooh, I wonder what the context of that quote is. Let's see. Article 2, Section 2, Clause 1. James Uredell, North Carolina ratifying convention. These are just minutes from the meeting, or from the debates, basically. Been the opinion of many gentlemen that the president should have a council. This opinion probably has been derived from the example in England. It'd be very proper for every gentleman to consider attentively whether that example ought to be imitated by us, although it would be a respectful example. It was very difficult immediately on a separation of Great Britain to disengage us entirely from the ideas of government we've been accustomed to a council under the old government, and took it for granted that we ought to have one under the new. When they talk about a council here, are they talking about like a council that would be elected, or they're not talking about just like a cabinet appointed by the president? I'm guessing they're talking about a council that comes from the parliament. Would be my guess. In that country, the executive authority is vested in a magistrate who holds it by birthright. He has great power. Oh, yes, because the council here would be limiting them by that definition, by that example, yeah. We've experienced that he can do no wrong, yet no man can say so in his own country. There are no courts. God, fuck. All of the initial conversations about the formation of like the structure of this country and the law and everything is so fucking based. It's so cool how intelligent these guys were and how much they were factoring when they were talking about the formation of the United States government. He has great powers and prerogatives, and it is a constitutional maxim that he can do no wrong. We have experienced that he can do wrong, yet no man can say so in his own country. There are no courts to try him for any high crimes, nor is there any constitutional method of depriving him of his throne. If he loses it, it must be by a general resistance of his people, contrary to forms of law, as at the revolution which took place about 100 years ago. It is therefore of the utmost moment in that country that whoever is the instrument of any act of government should be personally responsible for it, since the king is not. And for the same reason that no act of government should be exercised but by the instrumentality of some person who can be accountable for it. Everything, therefore, that the king does must be by some advice, and the advisor, of course, answerable. Under our Constitution, we are much happier. No man has an authority to injure another with impunity. No man is better than his fellow citizens, nor can we pretend to any superiority over the meanest man in the country. If the president does a single act by which the people are prejudiced, he is punishable himself, and no other man merely to screen him. If he commits any misdemeanors in office, he is impeachable, removable from office, and incapacitated to hold any office of honor, trust, or profit. If he commits any crime, he is punishable by the laws of his country, and in capital cases may be deprived of his life. Again, at the time also, this is a radical thing, right? You're creating a new government. You're coming from a king who can do no wrong to saying if we have a chief executive, we could literally execute him by our own laws. It's a huge 180 on, or turning on its head, the understanding of like a chief executor, I guess, or executive or a magistrate in any country. So he spells out both here, right? We have civil things, right? Or not, I'm so sorry, not civil things. We have impeachable offenses, right? That you can hold accountable by impeachment to remove from office. But also, and there are criminal things. There are criminal things of which you can be held accountable as well. This being the case, there is not the same reason here for having a council which exists in England. It is, however, much to be desired that a man who has such extensive and important business to perform should have the means of some assistance to enable him to discharge his arduous employment. The advice of the principal executive officers, which he can at all times command, will, in my opinion, answer this valuable purpose. He can at no time want advice if he desires it, as the principal officers will always be on the spot. There's also like good answers too. You know, one of the things people say, like, oh, like these are unelected people, these are unelected officials. Like my response has always been, well, you know, it's like it is a democracy. Like you're electing the president and he appoints people. So like to say that it's not a democracy because he appoints people is stupid. Like, and that is a decent answer. But like the more historically informed answer is, why would you want to elect co-equal members of power in the executive branch? Our government is explicitly designed that one man heads the executive. That is the explicit design of our government. And to vote with people with unanswerable power to other executives in the executive destroys the entire function by which the executive branch was founded. That's like a better, more informed, more historical answer. I personally just never considered. I guess this in real time is me exploring or discovering or finding out what I said before, where it's like when you read some things, it's like, well, this is kind of dumb. And then you look into it a little bit more, you're like, oh, okay, it makes sense, I guess. But I guess, I'm sorry, the other thing. Well, you think about a thing and it's like, yeah, it makes sense that there are a bunch of offices in the executive, and then you think about it and it's like, well, these people are unelected. Why is the FDA unelected? Why is this guy unelected? But then understanding the historical thing, it's like, okay, well, you can't have an executive that has other people sharing power that would turn the executive against itself. That check should come from the legislative. If the executive is to execute power from the legislative, it should be unquestioned in the executive, right? Yeah. Yeah, that would be the historical American founding argument for how our government is designed. But Sotomayor's citation here, in my opinion, and maybe I'm biased because I agree with her dissent, but in my opinion, the things that she cites to are much stronger advancements of her argument in terms of what's being written about than the one-line citations that were given by Roberts and Thomas, in my opinion. But be that as it may. Okay. Other commentators around the time of the founding observed that federal officials had no immunity from prosecution, drawing no exception for the president. James Wilson recognized that federal officers who use their official powers to commit crimes may be tried by their country, and if the criminality is established, the law will punish. A grand jury may present, a petty jury may convict, and the judges will pronounce the punishment. Interesting. A few decades later, Justice Story evinced the same understanding. He explained that when a federal official commits a crime in office, it is indispensable that provision should be made that the common tribunals of justice should be at liberty to entertain jurisdiction of the offense for the purpose of inflicting the common punishment applicable to unofficial offenders. Sotomayor. Why do I have her name spelled incorrectly? Makes reference to other historical arguments that support to the criminal charging of public officials acting in their official capacity. The common tribunals should be at liberty to entertain jurisdiction of the offense. Okay, boom, boom, boom. Okay. This historical evidence reinforces that, from the very beginning, the presumption in this nation has always been that no man is free to flout the criminal law. The majority fails to recognize or grapple with the lack of historical evidence for its new immunity. With nothing on its side of the ledger, the most the majority can do is claim that the historical evidence is a wash. It claims that the court previously has described the relevant historical evidence on the question of presidential immunity as fragmentary and not worthy of consideration. Yet the court has described only the evidence regarding the president's immunity from damages liability as fragmentary. True. That when she says, they say damages liability, when they're talking about that in the Supreme Court, they are exclusively referencing civil matters, right? Legal guy, correct me if I'm wrong. When you're talking about like paying damages or damages liability, you're talking about civil matters between two citizens, not a violation of a criminal statute. You don't pay damages, you pay fines, right? You don't. If somebody sues me for overdue rent, I don't pay a fine. I pay damages, right? I pay like restitution maybe? No, restitution might be a court thing too. To make sense, right? But you don't pay like damages. But if I get a criminal charge and then there's a fine that goes with my imprisonment, it's a fine. I'm not paying damages to the state. Although a state might be able to take you to civil court for violation of something as well. But anyway. Moreover, far from dismissing that evidence as irrelevant, the Fitzgerald court was careful to note that the best historical evidence clearly supported the immunity from damages liability that it recognized, and it relied in part on that historical evidence to overcome the lack of any textual basis for its immunity. The majority ignores this reliance. It seems history matters to this court only when it is convenient. See New York State Rifle and Pistol Association versus Bruin and Dobbs. True. Absolutely true and based, okay? This was a bananas ruling, okay, from the fucking majority. It seems like they only, I've said this many times, like history and text only matters when it supports our argument. But whatever, we've heard this many times, so fuck this, okay. Our country's history also points to an established understanding shared by both presidents and Justice Department that former presidents are answerable to the criminal law for their official acts. Oh, this wasn't even the history part? Can you explain why the Dobbs decision was bad? I will tread lightly on Dobbs because I wasn't amphetamine up for Dobbs, so I didn't read all of Dobbs. I might have read the summary part. But I think the issue people had with Dobbs is the conservative court wanted to fight against unenumerated powers. No, it wouldn't be unenumerated powers. I'm sorry. The concept of like a penumbra of rights, basically the idea that through reading some amendments, you could kind of fabricate these rights out of thin air, things like the right to privacy, that you could get them through a reading of other amendments. It seemed like the court was very against those types of atextual readings and those implications. They don't like, they say, well, we need like a stronger historical foundation, or we need like a stronger textual foundation in order to justify things like Roe v. Wade, or in order to justify Casey v. Planned Parenthood. But for this case, they have entirely fabricated with no historical foundation and with no textual support the idea of unrestricted absolute immunity for official presidential acts. That's a pretty big meme. But let's see. We're quoting this. Long settled and established practice may have great weight in a proper interpretation of constitutional provisions, quoting the pocket veto case. Consider Watergate, for example. Oh. After the Watergate tapes revealed President Nixon's misuse of official power to obstruct the Federal Bureau of Investigation's misuse of official power to obstruct the Federal Bureau of Investigation's investigation of the Watergate burglary, President Ford pardoned Nixon. Both Ford's pardon and Nixon's acceptance of that pardon necessarily rested on the understanding that the former president faced potential criminal liability. I don't know how you ever get around this. I don't know how you could possibly get around that. I have no clue how you get around that. I don't know. Did Roberts even touch this? I don't think Roberts even touched Nixon, except for to borrow quotations from it to try to support criminal liability when they were talking about civil liability. Like, ugh. Granting former President Nixon a full, free, and absolute pardon for all offenses against the United States which he has committed or may have committed or taken part in during his presidency. Accepting full and absolute pardon for any charges which might be brought against me for actions taken during the time I was President of the United States. So that was Nixon's acceptance of that pardon. I'm independent. In the Pierce video, it seems you're saying that you would rather us vote for a cabinet instead of a person, which has never happened. You're always voting for the president and his cabinet. That's literally always happening. That's what the executive branch is. Subsequent special counsel and independent counsel investigations have also operated on the assumption that the government can criminally prosecute former presidents for their official acts. Oh, actually, you know what would have been a good citation for the... I'm actually surprised that the majority opinion didn't further this opinion. Did Mueller refuse to recommend charges partially on the understanding that a sitting president couldn't be indicted? But that was for a sitting president. I'm still surprised it wasn't brought up, but I don't know. Yes, but not entirely the cabinet. That is what the Democrats seem to be asking us to do. Maybe, I don't know. I haven't seen any evidence that Biden can't perform the functions of the president of the United States. Can he debate? Well, maybe not. But he seems to be able to give speeches. The country seems to be running. He seems to be the president as much as anything else. I haven't seen evidence that he's incapable of performing the roles of that job, unless you're going to rest everything on his performance in a singular debate, in which case I will say that it is very funny. I said this on Piers Morgan, that all these people that I argue and debate with all day tell me that debate means nothing, debate doesn't matter, debate is irrelevant. But apparently now debate is literally the most job-determinative thing that any individual can actually do. And your performance in a debate is the most important aspect of your job. But... Subsequent special counsel and independent counsel investigations have also operated on the assumption, let's see, President of official act, they violate criminal law, Contra matters, Iran-Contra, because a president, and certainly a past president, is subject to prosecution. The conduct of President Reagan in the Iran-Contra matter was reviewed by independent counsel against the applicable statutes. It was concluded that his conduct fell well short of criminality, which could be successfully prosecuted. Okay. What if Nixon's Republican campaign officials' crime wasn't an official act? And what if that unofficial act didn't immunize him from prosecution? The majority opinion wouldn't comment on that, as it wasn't before the court. Okay. Indeed, Trump's own lawyers, during his second impeachment trial, assured senators that declining to impeach Trump for his conduct related to January 6th would not leave him in any way above the law. Oh, true. Proceedings of the U.S. Senate in the impeachment trial of Donald J. Trump, they insisted that a former president is like any other citizen and can be tried in a court of law. Trump's impeachment counsel stating that no former officeholder is immune from the judicial process for investigation, prosecution, and punishment. If my colleagues on this side of the chamber actually think that President Trump committed a criminal offense after he is out of office, you go and arrest him. Jesus. Now that Trump is facing criminal charges for those acts, though, the tune has changed. Being treated like any other citizen no longer seems so appealing. In sum, the majority today endorses an expansive vision of presidential immunity that was never recognized by the founders, any sitting president, the executive branch, or even President Trump's lawyers until now. Settled understandings of the Constitution are of little use to the majority in this case, and so it ignores them. Setting aside that evidence, the majority announces that former presidents are absolutely, or at least presumptively, immune from criminal prosecution for all of their official acts. The majority purports to keep us in suspense as to whether immunity is absolute or presumptive, but it quickly gives up the game. It explains that, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. God, that's saying, what does it mean? No dangers? Not little dangers, not only some dangers, not minor dangers. No dangers of intrusion? Oh, and she says it as much, yeah. No dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. Jesus Christ. Oh, and she's citing that Nixon case as well. Oh, so for the Nixon case, they even give tests. Huh. Okay, hold on real quick. Okay, I'm trying to describe broad Supreme Court shit. If an attorney disagrees with me, feel free to correct me, or a constitutional scholar, or somebody know, whatever. Somebody said, isn't the Supreme Court procrastinating dealing with the issue of what is an official action? They said the lower courts have to decide whether an act is official or unofficial, but Trump is going to dispute the results, so won't it inevitably go back to the Supreme Court? The Supreme Court is supposed to be the last stop for consideration of an issue. It's not supposed to be the first body that considers a particular thing as a general principle. So I think the Supreme Court is saying, listen, you guys are going to do the fact pattern to determine if it's an official or unofficial act, and then you guys are going to try to develop like a test or develop some way to figure out if you think it should be considered an official or unofficial act. And then when it gets to us, assuming it's still appealed, we'll look at it, we'll give it a review, and then we'll determine if we like it or we don't like it, basically. But the Supreme Court is not supposed to be, in principle, the first stop for those types of questions. It's supposed to be taken up by lower courts first, and then only given to the Supreme Court for final review, basically. Other intrusions may be just blah, 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 blah. Okay. According to the majority, however, any incursion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient hardly matters. Maybe some future opinion of this court will decide that presumptive immunity is sufficient and replace the majority's ironclad presumption with one that makes the difference between presumptive and absolute immunity meaningful. Today's court, however, has replaced a presumption of equality before the law with a presumption that the president is above the law for all of his official acts. Quick on the heels of announcing this astonishingly broad official acts immunity, the majority assures us that a former president can still be prosecuted for unofficial acts. Of course he can. No one has questioned the ability to prosecute a former president for unofficial, otherwise known as private, acts. Even Trump did not claim immunity for such acts, and, as the majority acknowledges, such an immunity would be impossible to square with Clinton v. Jones. This unremarkable proposition is no real limit on today's decision. It does not hide the majority's embrace of the most far-reaching view of presidential immunity on offer. In fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is not manifestly or palpably beyond his authority, he is taking official action. He then goes a step further in dividing official from unofficial conduct. Courts may not inquire into the president's motives. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it is quite another to make it irrelevant to questions regarding criminal liability. Under that rule, any use of official power for any purpose, even the most corrupt purpose indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed unofficial is destined to be vanishingly small. So she would say the difference between an official and unofficial act, the inability to probe motives or intents of anything that can be even slightly construed as an official act, essentially nullifies almost all criminal law from applying to almost all presidential actions. Ultimately, the majority pays lip service to the idea that the president charged with enforcing federal criminal laws is not above them, but it then proceeds to place former presidents beyond the reach of the federal criminal laws for any abuse of official power. So how does the majority get to its rule? Biden spends 90 unscripted minutes in public and is objectively senile. To now say that his obvious senility is failing at debating is so disingenuous that you and Harry Sisson should make out. That's great. So how does the majority get to its rule? With text, history, and established understanding all weighing against it, the majority claims just one arrow in its quiver. The balancing test in Nixon v. Fitzgerald, which, remember, Nixon v. Fitzgerald is a case concerning civil liability, damages for civil matters, not criminal liability, offenses against the state, okay? Or against citizens that the state is deemed wrong. Yet even that test cuts against it. The majority concludes that official acts immunity is required to safeguard the independence and effective functioning of the executive branch by rejecting that branch's own protestations that such immunity is not at all required and would in fact be harmful. In doing so, it decontextualizes Fitzgerald's language, ignores important qualifications, and reaches a result that the Fitzgerald court never would have countenanced. In Fitzgerald, plaintiff A. Ernest Fitzgerald sued then former President Nixon for money damages. He claimed that, while in office, Nixon had been involved in unlawfully firing him from his government job. The question for the court was whether a former president had immunity from such a civil suit. The court explained that it was settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. To determine whether a particular type of suit against a president could be heard, a court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. That balancing test is so much different than the one proposed by Roberts in the majority opinion. Like, notice here the difference in language, right? Here, the court is saying, that court was saying that you have to balance the weight of the interest to be served against the dangers of the intrusion. Whereas the court today is saying any intrusion is not acceptable, period, full stop. There is no balance. There's just a test to see if there's any intrusion into the executive's ability to perform at all. Destiny keeps harping on the civil comparison. Criminal law is considered to be more serious than civil law, so if you are granting immunity for civil, you would also grant immunity in criminal. I fully disagree. Criminal law as a category of things, I think, can be more severe than civil law, because as a category of things, criminal law is oftentimes regarding or talking about a deprivation of rights guaranteed to you by the Constitution. That's what criminal law results in you losing, essentially, right? Are these rights afforded to you by the Constitution? However, the threshold for charging criminal law is also, as a result, much higher. The threshold for an indictment and the threshold for a conviction are much higher. So to say that someone is entitled to civil immunity because it would make their job impossible, to say that it logically follows that they should also have all criminal immunity as well, I don't believe that logically follows. I've said this a million times. That's bullshit. Okay, sorry. Destiny, you can disagree, but that is how it works in the real world. That's why there is general criminal immunity with regards to certain government employees. Then you go done to civil. I'm sorry, David. What the fuck are you talking about? Can you cite me what you're referring to? Because apparently you're so fucking smart that you have understandings of criminal law that exceed even the Supreme Court. Because whatever you're referring to, where there is absolute criminal immunity provided to government officials, please cite what you're talking about. Because nobody here in any of the Supreme Court knows what the fuck you're talking about. Because I haven't seen any of those citations. So please share with us and email fucking Roberts while you're at it for whatever the fuck you're referring to. Please give us. Please tell me, what are you referring to? I don't know. Why am I even looking at chat expecting you to cite anything? If nobody in the Supreme Court knows what the fuck that you're talking about, why the fuck would I expect you to have it? Yeah, Jesus. Yes, all judges have absolute immunity for the work that they conduct from the bench. Absolute criminal immunity or absolute civil immunity? Because that immunity for judges was brought up, but I believe that was just civil. Let me check. Do judges have absolute criminal immunity on the bench? Judicial immunity and liability. This is for the Florida Judicial College. Judicial immunity shields judicial officials from damages, that means civil, flowing from, maybe there's a criminal thing here, flowing from acts taken while administering their judicial duties. The immunity is absolute immunity from suit, not just from the ultimate assessment of damages for judicial acts, even if the judge's executive authority is flawed by the commission of grave procedural errors. The doctrine of judicial embraces persons who exercise a judicial or quasi-judicial function. Yes, okay. So this is just from damages. This is from civil stuff, not criminal stuff. Go further. Does any of this talk about criminal? I don't think any of this. It looks like all of this has to do with civil, like with damages related stuff. Yeah, I don't know. Yeah, I don't think that there is. I don't think that exists. Okay. Make them research. I don't know why you're researching for them. Sure. Okay. On the facts before it, the court concluded that a merely private suit... Oh, wait. The court explained that when judicial action is needed to serve broad public interest, as when the court acts, not in derogation of the separation of powers, but to maintain their proper balance, or to vindicate the public interest in an ongoing criminal prosecution, the exercise of jurisdiction has been held warranted. On the facts before it, the court concluded that a merely private suit for damages based on a president's official acts did not serve those interests. The court reasoned that the visibility of the president's office and the effect of his actions on countless people made him an easy target for civil suits that frequently could distract him from his public duties. The public interest in such private civil suits, the court concluded, was comparatively weak. That's important. Remember, public interest. When we talk about criminal matters, I believe the assumption is that there is a big public interest. The public has a huge interest in, well, maybe, I don't know, fuck. We'll see what she says, sorry. Pretty sure. There is a lesser public interest in actions for civil damages than, for example, in criminal prosecution. Oh, okay, yeah, fuck you. Then, for example, in criminal prosecutions. Therefore, the court held that a former president was immune from such suits. In the context of a federal criminal prosecution for a former president, however, the danger to the functioning of the executive branch is much reduced. Further, as every member of the Fitzgerald Court acknowledged, the public interest in a criminal prosecution is far weightier. Applying the Fitzgerald balancing here should yield the opposite result. Instead, the majority elides any difference between civil and criminal immunity. Based, yes. Granting Trump the same immunity from criminal prosecution that Nixon enjoyed from an unlawful termination suit. That is plainly wrong. Yes, pre-read. I did pre-read this. These are the 25 pages I read. The majority relies almost entirely on its view of the danger of intrusion. Oh, I should probably write this down. Since the public has a greater interest in criminal prosecution than it does in private suits, the executive branch should need to provide a greater reason, not a lesser one, to evade such liability. The majority relies almost exclusively on its view of the danger of intrusion on the executive branch, to the exclusion of the other side of the balancing test. Yes, why wasn't the public interest ever addressed? Even in addressing the dissent, I feel like they don't ever address the other side of the equation. It is true, and we should all acknowledge, that we do want there to be an executive that can function free of worry of frivolous, even criminal suit. Sure, fuck it. We don't need like the president worrying about whether or not, I don't know, he's breaking a speed limiter. I don't know, just something frivolous or stupid that we wouldn't want him to be considering this when he's serving his role as president. But we also don't want a president that thinks he can infinitely commit criminal acts. We don't want that either. The public has a huge interest in not having a criminal president. Arguably, that is one of the largest public interests. He is the executor of law. Why would, of all the people who could commit criminal acts, is the king not the one that we are the most worried about? I don't think that's ever addressed a single time in the majority or either of the concurring opinions. But its analysis rests on a questionable conception of the president as incapable of navigating the difficult decisions his job requires while staying within the bounds of the law. It also ignores the fact that he receives robust legal advice on the lawfulness of his actions. Also true, there's a whole office. We cited an opinion earlier about Obama drone striking somebody. There's a whole office that confers with the president over the legality of a particular action. I know you're not done, but Noah Smith retweeted this thread of the Supreme Court decision. Do you largely agree? TLDR, it's bad, but some people are overhyping this into saying the SEAL Team 6 assassinating opponents being legal is dumb. Here comes like the liberal contrarians that want to pretend that, oh, everybody's doomsaying, so we're going to show how we're actually not doomsaying by being so reasonable and based, by being contrarian retards. It's like the people that anti-fan me in my community that want to show they're not just dusty dick riders. But okay. Okay, that's a... The majority says that the danger of intrusion on the authority and functions of the executive branch posed by criminally prosecuting a former president for official conduct is akin to, indeed, greater than, what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. It is, of course, important that the president be able to deal fearlessly and impartially with the duties of his office. If every action the president takes exposes him personally to vexatious private litigation, the possibility of hamstringing presidential decision-making is very real. Yet, there are many facets of criminal liability, which the majority discounts, that make it less likely to chill the presidential action than the threat of civil litigation. First, in terms of probability, the threat of criminal liability is much smaller, yes. In Fitzgerald, the threat of vexatious civil litigation loomed large. This is why I said I wish that Roberts would have given us examples. What are all of these examples of potential, like, criminal issues that the president could run into in the ordinary course of performing core presidential duties? Can you give even one example? But you should give several. Like what actions of the president are being chilled by making them criminally liable? I don't think they gave a single one in the majority or the concurrence. Why? What would it be? We should have questions for debates. Can you give a single example of an action a president might want to take that would be chilled by him being criminally liable, even for core actions, even for the core functions of his office? Hold on, let me use the restroom real quick.